The Crown versus Oakes, 1986. This appeal concerns the constitutionality of Section 8 of the Narcotic Control Act. The section provides, in brief, that if the court finds the accused in possession of a narcotic, he is presumed to be in possession for the purpose of trafficking. Unless the accused can establish to the contrary, he must be convicted of trafficking. The Ontario Court of Appeal held that this provision constitutes a reverse onus clause and is unconstitutional because it violates one of the core values of our criminal justice system, the presumption of innocence, now entrenched in Section 11D of the Canadian Charter of Rights and Freedoms. The Crown has appealed. Statutory and constitutional provisions. Before reviewing the factual context, I will set out the relevant legislative and constitutional provisions. Narcotic Control Act. Section 3(1). Except as authorized by this Act, or the regulations, no person shall have a narcotic in his possession. 2. Every person who violates subsection 1 is guilty of an indictable offense and is liable, a. upon summary conviction for a first offense, to a fine of $1,000, or to imprisonment for 6 months, or to both fine and imprisonment, and for a subsequent offense, to a fine of $2,000, or to imprisonment for 1 year, or to both fine and imprisonment, or b. upon conviction on indictment, to imprisonment for 7 years. Section 4(1). No person shall traffic in a narcotic or any substance represented or held out by him to be a narcotic. 2. No person shall have in his possession a narcotic for the purpose of trafficking. 3. Every person who violates subsection 1 or 2 is guilty of an indictable offense and is liable to imprisonment for life. Section 8. In any prosecution for a violation of subsection 4(2), if the accused does not plead guilty, the trial shall proceed as if it were a prosecution for an offense under Section 3, and after the close of the case for the prosecution, and after the accused has had an opportunity to make full answer in defense, the court shall make a finding as to whether or not the accused was in possession of the narcotic, contrary to Section 3. If the court finds that the accused was not in possession of the narcotic, contrary to Section 3, he shall be acquitted, but if the court finds that the accused was in possession of the narcotic, contrary to Section 3, he shall be given an opportunity of establishing that he was not in possession of the narcotic for the purpose of trafficking, and thereafter the prosecutor shall be given an opportunity of adducing evidence to establish that the accused was in possession of the narcotic for the purpose of trafficking. If the accused establishes that he was not in possession of the narcotic for the purpose of trafficking, he shall be acquitted of the offense as charged, but he shall be convicted of an offense under Section 3 and sentenced accordingly. And, if the accused fails to establish that he was not in possession of the narcotic for the purpose of trafficking, he shall be convicted of the offense as charged and sentenced accordingly. Canadian Charter of Rights and Freedoms. Section 11. Any person charged with an offense has the right d. to be presumed innocent until proven guilty, according to law, in a fair and public hearing by an independent and impartial tribunal. 1. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Facts. The respondent, David Edwin Oakes, was charged with unlawful possession of a narcotic for the purpose of trafficking, contrary to Section 4(2) of the Narcotic Control Act. He elected trial by magistrate without a jury. At trial, the Crown adduced evidence to establish that Mr. Oakes was found in possession of 8 1-gram vials of cannabis resin in the form of hashish oil. Upon a further search conducted at the police station, $619.45 was located. Mr. Oakes told the police that he had bought 10 vials of hashish oil for $150 for his own use, and that the $619.45 was from a workers' compensation check. He elected not to call evidence as to possession of the narcotic. Pursuant to the procedural provisions of Section 8 of the Narcotic Control Act, the trial judge proceeded to make a finding that it was beyond a reasonable doubt that Mr. Oakes was in possession of the narcotic. Following this finding, Mr. Oakes brought a motion to challenge the constitutional validity of Section 8 of the Narcotic Control Act, which he maintained imposes a burden on an accused to prove that he or she was not in possession for the purpose of trafficking. He argued that Section 8 violates the presumption of innocence contained in Section 11D of the Charter. Judgments. A. Ontario Provincial Court, The Crown v. Oakes, 1982. At trial, Provincial Court Justice Walker borrowed the words of Chief Justice Laskin in The Crown v. Shelley, 1981, and found that there was no rationale or necessary connection between the fact proved, i.e., possession of the drug, and the conclusion asked to be drawn, namely possession for the purpose of trafficking. Provincial Court Justice Walker held that to the extent that Section 8 of the Narcotic Control Act requires this presumption and the resultant conviction, it is inoperative as a violation of the presumption of innocence contained in Section 11D of the Charter. Provincial Court Justice Walker added that the reverse onus in Section 8 would not be invalid if the Crown had adduced evidence of possession as well as evidence from which it could be inferred beyond a reasonable doubt that the possession was for the purpose of trafficking. If this were done, there would be a sufficient rational connection between the fact of possession and the presumed fact of trafficking. B. Ontario Court of Appeal, The Crown v. Oakes, 1983. Justice of Appeal Martin, writing for a unanimous court, dismissed the appeal and held the reverse onus provision in Section 8 of the Narcotic Control Act unconstitutional. Justice of Appeal Martin stated that as a general rule, a reverse onus clause which places a burden on the accused to disprove on a balance of probabilities an essential element of an offense contravenes the right to be presumed innocent. Nevertheless, he held that some reverse onus provisions may be constitutionally valid provided they constitute reasonable limitations on the right to be presumed innocent and are demonstrably justified in a free and democratic society. To determine whether a particular reverse onus provision is legitimate, Justice of Appeal Martin outlined a two-pronged inquiry. First, it is necessary to pass a threshold test, which he explained as follows at page 146. The threshold question in determining the legitimacy of a particular reverse onus provision is whether the reverse onus clause is justifiable in the sense that it is reasonable for Parliament to place the burden of proof on the accused in relation to an ingredient of the offence in question. In determining the threshold question, consideration should be given to a number of factors, including such factors as a. The magnitude of the evil sought to be suppressed, which may be measured by the gravity of the harm resulting from the offence, or by the frequency of the occurrence of the offence, or by both criteria. B. The difficulty of the prosecution making proof of the presumed fact, and C. The relative ease with which the accused may prove or disprove the presumed fact. Manifestly, a reversed onus provision placing the burden of proof on the accused with respect to a fact which it is not rationally open to him to prove or disprove cannot be justified. If the reverse onus provision meets these criteria, due regard having been given to Parliament's assessment of the need for the provision, a second test must then be satisfied. The second test was described by Justice of Appeal Martin as the rational connection test. According to it, to be reasonable, the proven fact, e.g. possession, must rationally tend to prove the presumed fact, e.g. an intention to traffic. In other words, the proven fact must raise a probability that the presumed fact exists. In considering Section 8 of the Narcotic Control Act, Justice of Appeal Martin focused primarily on the second test at page 147. I have reached the conclusion that Section 8 of the Narcotic Control Act is constitutionally invalid because of the lack of a rational connection between the proved fact, possession, and the presumed fact, an intention to traffic. Mere possession of a small quantity of a narcotic drug does not support an inference of possession for the purpose of trafficking, or even tend to prove an intent to traffic. Moreover, upon proof of possession, Section 8 casts upon the accused the burden of disproving not some formal element of the offense, but the burden of disproving the very essence of the offense. Justice of Appeal Martin added that it is not for courts to attempt to rewrite Section 8 by applying it on a case-by-case basis. Furthermore, where a rational connection does exist between possession and the presumed intention to traffic, such as where the possession of a narcotic drug is of such a nature as to be indicative of trafficking, the common sense of a jury can ordinarily be relied upon to arrive at a proper conclusion. There would not, therefore, be any need for a statutory presumption. One final note should be made regarding Justice of Appeal Martin's judgment. In assessing whether or not Section 8 was a reasonable limitation on the constitutional protection of the presumption of innocence, Justice of Appeal Martin combined the analysis of Section 11D with Section 1. He held that the requirements of Section 1, that a limitation be reasonable and demonstrably justified in a free and democratic society, provided the standard for interpreting the phrase according to law in Section 11D. The issues. The constitutional question in this appeal is stated as follows. Is Section 8 of the Narcotic Control Act inconsistent with Section 11D of the Canadian Charter of Rights and Freedoms, and thus of no force and effect? Two specific questions are raised by this general question. 1. Does Section 8 of the Narcotic Control Act violate Section 11D of the Charter? And 2. If it does, is Section 8 a reasonable limit prescribed by law as can be demonstrably justified in a free and democratic society for the purpose of Section 1 of the Charter? If the answer to 1 is affirmative and the answer to 2 negative, then the constitutional question must be answered in the affirmative. Does Section 8 of the Narcotic Control Act violate Section 11D of the Charter? A. The meaning of Section 8. Before examining the presumption of innocence contained in Section 11D of the Charter, it is necessary to clarify the meaning of Section 8 of the Narcotic Control Act. The procedural steps contemplated by Section 8 were clearly outlined by Justice of Appeal Branca in the Crown v. Babcock and Auld, 1966. A. The accused is charged with possession of a forbidden drug for the purpose of trafficking. B. The trial of the accused on this charge then proceeds as if it were a prosecution against the accused on a simple charge of possession of the forbidden drug. C. When the Crown has adduced its evidence on the basis that the charge was a prosecution for simple possession, the accused is then given the statutory right or opportunity of making a full answer in defense to the charge of simple possession. D. When this has been done, the court must make a finding as to whether the accused was in possession of narcotics, contrary to Section 3 of the new Act, unlawful possession of a forbidden narcotic drug. E. Assuming that the court so finds, it is then that an onus is placed upon the accused in the sense that an opportunity must be given to the accused of establishing that he was not in possession of a narcotic for the purpose of trafficking. F. When the accused has been given this opportunity, the prosecutor may then establish that the possession of the accused was for the purpose of trafficking. G. It is then that the court must find whether or not the accused has discharged the onus placed upon him under and by the said section. H. If the court so finds, the accused must be acquitted of the offences charged, namely possession for the purpose of trafficking, but in that event, the accused must be convicted of the simple charge of unlawful possession of a forbidden narcotic. I. If the accused does not so establish, he must then be convicted of the full offence as charged. Mr. Justice Branca then added, at pages 247 and 48. It is quite clear to me that under Section 8 of the new Act, the trial must be divided into two phases. In the first phase, the sole issue to be determined is whether or not the accused is guilty of simple possession of a narcotic. This issue is to be determined upon evidence relevant only to the issue of possession. In the second phase, the question to be resolved is whether or not the possession charged is for the purpose of trafficking. Against the backdrop of these procedural steps, we must consider the nature of the statutory presumption contained in Section 8 and the type of burden it places on an accused. The relevant portions of Section 8 read, "If the court finds that the accused was in possession of the narcotic, he shall be given an opportunity of establishing that he was not in possession of the narcotic for the purpose of trafficking. If the accused fails to establish that he was not in possession of the narcotic for the purpose of trafficking, he shall be convicted of the offense as charged." In determining the meaning of these words, it is helpful to consider, in a general sense, the nature of presumptions. Presumptions can be classified into two general categories: presumptions without basic facts and presumptions with basic facts. A presumption without a basic fact is simply a conclusion which is to be drawn until the contrary is proved. A presumption with a basic fact entails a conclusion to be drawn upon proof of the basic fact. Basic fact presumptions can be further categorized into permissive and mandatory presumptions. A permissive presumption leaves it optional as to whether the inference of the presumed fact is drawn following proof of the basic fact. A mandatory presumption requires that the inference be made. Presumptions may also be either rebuttable or irrebuttable. If a presumption is rebuttable, there are three potential ways the presumed fact can be rebutted. First, the accused may be required merely to raise a reasonable doubt as to its existence. Secondly, the accused may have an evidentiary burden to adduce sufficient evidence to bring into question the truth of the presumed fact. Thirdly, the accused may have a legal or persuasive burden to prove on a balance of probabilities the non-existence of the presumed fact. Finally, presumptions are often referred to as either presumptions of law or presumptions of fact. The latter entail frequently recurring examples of circumstantial evidence, while the former involve actual legal rules. To return to Section 8 of the Narcotic Control Act, it is my view that upon a finding beyond a reasonable doubt of possession of a narcotic, the accused has the legal burden of proving on a balance of probabilities that he or she was not in possession of the narcotic for the purpose of trafficking. Once the basic fact of possession is proven, a mandatory presumption of law arises against the accused that he or she had the intention to traffic. Moreover, the accused will be found guilty of the offense of trafficking unless he or she can rebut this presumption on a balance of probabilities. This interpretation of Section 8 is supported by the courts in a number of jurisdictions. In some decisions, it has been held that Section 8 of the Narcotic Control Act is constitutional because it places only an evidentiary burden rather than a legal burden on the accused. The ultimate legal burden to prove guilt beyond a reasonable doubt remains with the Crown, and the presumption of innocence is not offended. The same approach was relied on in the Crown v. Sharp, 1961, a Canadian Bill of Rights decision on the presumption of innocence. In that case, a provision in the Opium and Narcotic Drug Act, similar to Section 8 of the Narcotic Control Act, was interpreted as shifting merely the secondary burden of adducing evidence onto the accused. The primary onus remained with the Crown. In the Crown v. Silk, 1971, the British Columbia Court of Appeal held that Section 2F of the Canadian Bill of Rights had not been infringed because Section 33 of the Food and Drugs Act required only that an accused raise a reasonable doubt that the purpose of his or her possession was trafficking. This decision, however, was not followed in the Crown v. Appleby, 1971, nor in the Crown v. Erdman, 1971. Those decisions, which have held that only the secondary or evidentiary burden shifts, are not persuasive with respect to the Narcotic Control Act. As Justice Ritchie found, in the Crown v. Appleby, supra, though addressing a different statutory provision, The phrase to establish is the equivalent of to prove. The legislature, by using the word establish in Section 8 of the Narcotic Control Act, intended to impose a legal burden on the accused. This is most apparent in the words, if the accused fails to establish that he was not in possession of narcotic for the purpose of trafficking, he shall be convicted of the offense as charged. In the Appleby case, Justice Ritchie also held that the accused is required to disprove the presumed fact according to the civil standard of proof on a balance of probabilities. He rejected the criminal standard of beyond a reasonable doubt, relying, inter alia, upon the following passage from the House of Lords decision in Public Prosecutor v. Yuvaraj, 1970, at page 232. Generally speaking, no onus lies upon a defendant in criminal proceedings to prove or disprove any fact. It is sufficient for his acquittal if any of the facts which, if they existed, would constitute the offense with which he is charged are not proved. But exceptionally, as in the present case, an enactment creating an offense expressly provides that if other facts are proved, a particular fact, the existence of which is a necessary factual ingredient of the offense, shall be presumed or deemed to exist unless the contrary is proved. In such a case, the consequence of finding that the particular fact is disproved will be an acquittal, whereas the absence of such a finding will have the consequence of a conviction. Where this is the consequence of a fact's being disproved, there can be no grounds in public policy for requiring that exceptional degree of certainty as excludes all reasonable doubt that the fact does not exist. In their lordship's opinion, the general rule applies in such a case and is sufficient if the court considers that upon the evidence before it, it is more likely than not that the fact does not exist. The test is the same as that applied in civil proceedings, the balance of probabilities. I conclude that Section 8 of the Narcotic Control Act contains a reverse onus provision, imposing a legal burden on an accused to prove on a balance of probabilities that he or she was not in possession of a narcotic for the purpose of trafficking. It is therefore necessary to determine whether Section 8 of the Narcotic Control Act offends the right to be presumed innocent until proven guilty, as guaranteed by Section 11D of the Charter. B. The presumption of innocence in Section 11D of the Charter. Section 11D of the Charter constitutionally entrenches the presumption of innocence as part of the supreme law of Canada. For ease of reference, I set out this provision again. Section 11. Any person charged with an offence has the right D. to be presumed innocent until proven guilty, according to law, in a fair and public hearing by an independent and impartial tribunal. To interpret the meaning of Section 11D, it is important to adopt a purposive approach. As this court stated in the Crown v. Big M Drug Mart Limited, 1985, at page 344, the meaning of a right or freedom guaranteed by the Charter was to be ascertained by an analysis of the purpose of such a guarantee. It was to be understood, in other words, in the light of the interests it was meant to protect. In my view, this analysis is to be undertaken, and the purpose of the right or freedom in question is to be sought by reference to the character and the larger objects of the Charter itself, to the language chosen to articulate the specific right or freedom, to the historical origins of the concepts enshrined, and where applicable, to the meaning and purpose of the other specific rights and freedoms. To identify the underlying purpose of the Charter right in question, therefore, it is important to begin by understanding the cardinal values it embodies. The presumption of innocence is a hallowed principle lying at the very heart of criminal law. Although protected expressly in Section 11D of the Charter, the presumption of innocence is referable and integral to the general protection of life, liberty, and security of the person contained in Section 7 of the Charter. The presumption of innocence protects the fundamental liberty and human dignity of any and every person accused by the state of criminal conduct. An individual charged with a criminal offense faces grave social and personal consequences, including potential loss of physical liberty, subjection to social stigma, and ostracism from the community, as well as other social, psychological, and economic harms. In light of the gravity of these consequences, the presumption of innocence is crucial. It ensures that until the state proves an accused's guilt beyond all reasonable doubt, he or she is innocent. This is essential in a society committed to fairness and social justice. The presumption of innocence confirms our faith in humankind. It reflects our belief that individuals are decent and law-abiding members of the community until proven otherwise. The presumption of innocence has enjoyed long-standing recognition at common law. In the leading case, Wilmington v. Director of Public Prosecutions, 1935, Viscount Sankey wrote, at pages 481-82, "Throughout the web of English criminal law, one golden thread is always to be seen, that is the duty of the prosecution to prove the prisoner's guilt, subject to what I have already said as to the defense of insanity, and subject also to any statutory exception, if, at the end of, and on the whole of the case, there is a reasonable doubt, created by the evidence given by either the prosecution or the prisoner, as to whether the prisoner killed the deceased with a malicious intention, the prosecution has not made out the case, and the prisoner is entitled to an acquittal. No matter what the charge or where the trial, the principle that the prosecution must prove the guilt of the prisoner is part of the common law of England, and no attempt to whittle it down can be entertained." Subsequent Canadian cases have cited the Wilmington principle with approval. Further evidence of the widespread acceptance of the principle of the presumption of innocence is its inclusion in the major international human rights documents. Article 11.1 of the Universal Declaration of Human Rights, adopted December 10, 1948, by the General Assembly of the United Nations, provides, "Everyone charged with a penal offense has the right to be presumed innocent until proved guilty, according to law, in a public trial at which he has had all the guarantees necessary for his defense." And the International Covenant on Civil and Political Rights, 1966, Article 14.2 states, "Everyone charged with a criminal offense shall have the right to be presumed innocent until proved guilty according to law." Canada acceded to this covenant and the optional protocol which sets up machinery for implementing the covenant on May 19, 1976. Both came into effect on August 19, 1976. In light of the above, the right to be presumed innocent until proven guilty requires that Section 11D have, at minimum, the following content. First, an individual must be proven guilty beyond a reasonable doubt. Second, it is the state which must bear the burden of proof. As Justice Lemaire stated in Dubois v. the Queen, 1985, at page 357, Section 11D imposes upon the Crown the burden of proving the accused's guilt beyond a reasonable doubt, as well as that of making out the case against the accused before he or she need respond, either by testifying or calling other evidence. Third, criminal prosecutions must be carried out in accordance with lawful procedures and fairness. The latter part of Section 11D, which requires the proof of guilt according to law in a fair and public hearing by an independent and impartial tribunal, underlines the importance of this procedural requirement. C. Authorities on reverse onus provisions and the presumption of innocence. Having considered the general meaning of the presumption of innocence, it is now, I think, desirable to review briefly the authorities on reverse onus clauses in Canada and other jurisdictions. 1. The Canadian Bill of Rights jurisprudence. Section 2F of the Canadian Bill of Rights, which safeguards the presumption of innocence, provides, "Every law of Canada shall, unless it is expressly declared by an Act of Parliament of Canada that it shall operate notwithstanding the Canadian Bill of Rights, be so construed and applied as not to abrogate, abridge, or infringe, or to authorize the abrogation, abridgment, or infringement of any of the rights or freedoms herein recognized and declared, and in particular, no law of Canada shall be construed or applied so as to f. Deprive a person charged with a criminal offense of the right to be presumed innocent until proved guilty according to law in a fair and public hearing by an independent and impartial tribunal." The wording of the section closely parallels that of Section 11D. For this reason, one of the Crown's primary contentions is that the Canadian Bill of Rights jurisprudence should be determinative of the outcome of the present appeal. The leading case, decided under Section 2F of the Canadian Bill of Rights and relied on by the Crown in the Crown v. Appleby, Supra. In that case, the accused had challenged Section 224A1A of the Criminal Code, which imposes a burden upon an accused to prove that he or she, though occupying the driver's seat, did not enter the vehicle for the purpose of setting it in motion and did not, therefore, have care and control. This court rejected the arguments of the accused that Section 2F had been violated. It relied on the Wilmington case, which held that the presumption of innocence was subject to statutory exceptions. As Justice Ritchie stated in his judgment for the majority at pages 315-16, it seems to me, therefore, that if Wilmington's case is to be accepted, the words presumed innocent until proved guilty according to law, as they appear in Section 2F of the Bill of Rights, must be taken to envisage a law which recognizes the existence of statutory exceptions reversing the onus of proof with respect to one or more ingredients of an offense in cases where certain specific facts have been proved by the Crown in relation to such ingredients. In a concurring opinion, Justice Laskin put forward an alternative test. He chose not to follow Justice Ritchie's approach of reading a statutory exception limitation into the phrase according to law in Section 2F of the Canadian Bill of Rights, and said at page 317, "I do not construe Section 2F as self-defeating because of the phrase according to law which appears therein. Hence, it would be offensive to Section 2F for a federal criminal enactment to place upon the accused the ultimate burden of establishing his innocence with respect to any element of the offense charged. The right to be presumed innocent, of which Section 2F speaks, is, in popular terms, a way of expressing the fact that the Crown has the ultimate burden of establishing guilt. If there is any reasonable doubt at the conclusion of the case on any element of the offense charged, an accused person must be acquitted. In a more refined sense, the presumption of innocence gives an accused the initial benefit of a right to silence and the ultimate benefit, after the Crown's evidence is in, and as well any evidence tendered on behalf of the accused, of any reasonable doubt." Nevertheless, Justice Laskin went on to hold that the presumption of innocence is not violated by any statutory or non-statutory burden upon an accused to adduce evidence to neutralize or counter on a balance of probabilities the effective evidence presented by the Crown. The test, according to Justice Laskin, is whether the legislative provision calls for a finding of guilt even though there is a reasonable doubt as to the culpability of the accused. This would seem to prohibit the imposition of any legal burden on the accused. However, Justice Laskin upheld a statutory provision which would appear to have done precisely that. In a subsequent case, the Crown v. Shelley Supra, involving a reverse onus provision regarding unlawful importation, Chief Justice Laskin discussed further the views he had articulated in Appleby at page 200. This court held in the Crown v. Appleby that a reverse onus provision, which goes no farther than to require an accused to offer proof on a balance of probabilities, does not necessarily violate the presumption of innocence under Section 2F. It would, of course, be clearly incompatible with Section 2F for a statute to put upon an accused a reverse onus of proving a fact in issue beyond a reasonable doubt. Insofar as the onus goes no farther than to require an accused to prove as essential fact upon a balance of probabilities, the essential fact must be one which is rationally open to the accused to prove or disprove, as the case may be. If it is one which an accused cannot reasonably be expected to prove, being beyond his knowledge or beyond what he may reasonably be expected to know, it amounts to a requirement that is impossible to meet. In addition, Chief Justice Laskin sowed the seeds for the development of a rational connection test for determining the validity of a reverse onus provision when he stated at page 202, "It is evident to me in this case that there is on the record no rational or necessary connection between the fact provided, i.e., possession of goods of foreign origin, and the conclusion of unlawful importation, which the accused under Section 248(1) must, to avoid conviction, disprove." Although there are important lessons to be learned from the Canadian Bill of Rights jurisprudence, it does not constitute binding authority in relation to the constitutional interpretation of the Charter. As this court held in the Crown v. Big M Drug Mart Limited, Supra, the Charter, as a constitutional document, is fundamentally different from the statutory Canadian Bill of Rights, which was interpreted as simply recognizing and declaring existing rights. In rejecting the Canadian Bill of Rights religion cases as determinative of the meaning of freedom of religion under the Charter in the Crown v. Big M Drug Mart Limited, the court had occasion to say, at pages 343-44, I agree with the submission of the respondent that the Charter is intended to set a standard upon which present as well as future legislation is to be tested. Therefore, the meaning of the concept of freedom of conscience and religion is not to be determined solely by the degree to which that right was enjoyed by Canadians prior to the proclamation of the Charter. For this reason, Robertson and Rosatani Supra cannot be determinative of the meaning of freedom of conscience and religion under the Charter. We must look, rather, to the distinct principles of constitutional interpretation appropriate to expounding the supreme law of Canada. With this in mind, one cannot but question the appropriateness of reading into the phrase according to law in Section 11D of the Charter the statutory exceptions acknowledged in Wilmington and in Appleby. The Wilmington case was decided in the context of a legal system with no constitutionally entrenched human rights document. In Canada, we have tempered parliamentary supremacy by entrenching important rights and freedoms in the Constitution. Viscount Sankey's statutory exception proviso is clearly not applicable in this context and would subvert the very purpose of the entrenchment of the presumption of innocence in the Charter. I do not, therefore, feel constrained in this case by the interpretation of Section 2F of the Canadian Bill of Rights presented in the majority judgment in Appleby. Section 8 of the Narcotic Control Act is not rendered constitutionally valid simply by virtue of the fact that it is a statutory provision. 2. Canadian Charter jurisprudence. In addition to the present case, there have been a number of other provincial appellate-level judgments addressing the meaning of the presumption of innocence contained in Section 11D. This jurisprudence provides a comprehensive and persuasive source of insight into the questions raised in this appeal. In particular, 6 appellate-level courts, in addition to the Ontario Court of Appeal, have held that Section 8 of the Narcotic Control Act violates the Charter. Following the decision of the Ontario Court of Appeal in the present case, the Prince Edward Island Supreme Court, in Banco, rendered its decision in the Crown v. Carroll, Supra, writing for the majority, Justice MacDonald, held at page 105. Unless a provision falls within Section 1 of the Charter, there cannot be a requirement that an accused must prove an essential positive element of the Crown's case, other than by raising a reasonable doubt. The presumption of innocence cannot be said to exist if by shifting the persuasive burden the court is required to convict, even if a reasonable doubt may be said to exist. In a concurring judgment, Justice Mitchell commented at pages 107 and 8, Section 11D gives an accused person the right to be presumed innocent until proven guilty. It follows that if an accused is to be presumed innocent until proven guilty, he must not be convicted unless and until the Crown has proven each and all of the elements necessary to constitute the crime. Applying these legal conclusions to Section 8 of the Narcotic Control Act, the court held that Section 11D had been violated. As Justice Mitchell stated at page 108, under Section 8, an accused is not presumed innocent until proven guilty. He is only presumed innocent until found in possession. Once the Crown proves the accused had possession of the narcotic, he is presumed to be guilty of an intention to traffic until he proves otherwise. The Nova Scotia Supreme Court, Appellate Division, also concluded that Section 8 is an unconstitutional violation of the Section 11D presumption of innocence and its decision in the Crown v. Cook, Supra, after reviewing the Crown v. Oakes, Supra, and the Crown v. Carroll, Supra. Justice of P.L. Hart concluded at pages 435 to 36. Section 8 of the Narcotic Control Act is a piece of legislation that attempts to relieve the Crown of its normal burden of proof by use of what is known as a reverse onus. Different types of reverse onus have been known to the law and proof of a case with the aid of a reverse onus can, in my opinion, fall into the wording of Section 11D of the Charter as being proof according to law. I know of no justification, however, for holding that it would be according to law to allow use of a reverse onus clause which permitted the Crown the assistance of a provision which relieved it from calling any probative evidence to establish one of the essential elements of an offence. Although concurring in result, Justice of Appeal Jones maintained that the reasonableness test should be applied with respect to Section 1 and not with respect to the words according to law in Section 11D. The test of reasonableness should be available in considering the secondary question under Section 1 of the Charter. It is important that the burden of proof should be on the Crown to show that a statute which violates Section 11D of the Charter is demonstrably justified in a free and democratic society. In the Crown v. O'Day, Supra, the New Brunswick Court of Appeal struck down Section 8 of the Narcotic Control Act and registered its agreement with the 3 earlier provincial appellate-level courts. The Alberta Court of Appeal in the Crown v. Stanger, Supra, also found Section 8 unconstitutional. However, the court was not unanimous in this conclusion. On the meaning of Section 11D, Justice of Appeal Stevenson, writing for the majority, paraphrased Justice of Appeal Martin's comment in Oakes and stated at page 351 that the presumption of innocence meant, first, that an accused is innocent until proven guilty in accordance with the established procedure, and secondly, that guilt must be proven beyond a reasonable doubt. Mr. Justice Stevenson also cited Justice MacDonald's comment in Carroll that the presumption of innocence is maintained as long as the prosecution has the final burden of establishing guilt on any element of the offence charged beyond a reasonable doubt. I should add that the majority, in Stanger, correctly rejected the applicability of the Privy Council decision in Ong An Chuan v. Public Prosecutor 1981. That case concerned the constitutional provisions of Singapore, which are significantly different from those of the Charter. In particular, they do not contain an explicit endorsement of the presumption of innocence. Moreover, the Privy Council did not read this principle into the general due process protections of the Constitution of Singapore. In the Crown v. Landry, Supra, the Quebec Court of Appeal invalidated Section 8 of the Narcotic Control Act and extended its conclusions to Section 2F of the Canadian Bill of Rights. As Justice of Appeal Malot stated at page 561, both the Bill of Rights and the Charter recognize the right of an accused to be presumed innocent until proven guilty according to law. I cannot accept that such a basic and fundamental principle can be set aside by such a reverse onus provision. Finally, in a very brief judgment, the Crown v. Stock, Supra, the British Columbia Court of Appeal concurred with the Court of Appeal decisions reviewed above, endorsing in particular the Ontario Court of Appeal decision in Oakes. An earlier British Columbia Court of Appeal opinion, re Anson and the Queen, 1983, had dismissed an appeal from a ruling which had upheld the constitutionality of Section 8 of the Narcotic Control Act. However, the basis for the denial of the appeal was procedural. The court did not assess the constitutionality of Section 8 in relation to the presumption of innocence. There have also been a number of cases in which the meaning of Section 11D has been considered in relation to other legislative provisions. To summarize, the Canadian Charter jurisprudence on the presumption of innocence in Section 11D and reverse onus provisions appears to have solidly accorded a high degree of protection to the presumption of innocence. Any infringements of this right are permissible only when, in the words of Section 1 of the Charter, they are reasonable and demonstrably justified in a free and democratic society. 3. United States jurisprudence. In the United States, protection of the presumption of innocence is not explicit. Rather, it has been read into the due process provisions of the American Bill of Rights contained in the 5th and 14th Amendments of the Constitution of the United States of America. An extensive review of the United States case law is provided in Justice of Appeal Martin's judgment for the Ontario Court of Appeal. I will therefore merely highlight the major jurisprudential developments. In Tott v. United States, 1943, Justice Roberts outlined the following test at pages 467 to 68. A statutory presumption cannot be sustained if there be no rational connection between the fact proved and the ultimate fact presumed, if the inference of the one from the proof of the other is arbitrary because of lack of connection between the two in common experience. The comparative convenience of producing evidence was also acknowledged as a corollary test. The case involved a presumption to be drawn from the possession of firearms by a person convicted of a previous crime of violence that the firearms were illegally obtained through interstate or foreign commerce. Of note was Justice Roberts' comment that even if a rational connection had been proved, the statutory presumption could not be sustained because of the prejudicial reliance on a past conviction as part of the basic fact. The accused would be discredited in the eyes of the jury even before he attempted to disprove the presumed fact. In Leary v. United States, 1969, Justice Harlan articulated a more stringent test for invalidity at page 36. A criminal statutory presumption must be regarded as irrational or arbitrary and hence unconstitutional, unless it can be at least said with substantial assurance that the presumed fact is more likely than not to flow from the proved fact on which it is made to depend. Justice Harlan also noted that since the statutory presumption was invalid under the above test, we need not reach the question whether a criminal presumption which passes muster when so judged must also satisfy the criminal reasonable doubt standard if proof of the crime charged or an essential element thereof depends upon its use. The United States Supreme Court did answer this question in County Court of Ulster County, New York v. Allen, 1979. It held that where a mandatory criminal presumption was imposed by statute, the state may not rest its case entirely on a presumption unless the fact proved is sufficient to support the inference of guilt beyond a reasonable doubt. A mere rational connection is insufficient. This case illustrates the high degree of constitutional protection accorded to the principle that an accused must be found guilty beyond a reasonable doubt. The rationale for this is well stated by Justice Brandon in Re Winship, 1970, at pages 363 to 64. The requirement of proof beyond a reasonable doubt has this vital role in our criminal procedure for cogent reasons. The accused during a criminal prosecution has at stake interests of immense importance, both because of the possibility that he may lose his liberty upon conviction and because of the certainty that he would be stigmatized by the conviction. Accordingly, a society that values the good name and freedom of every individual should not condemn a man for commission of a crime when there is reasonable doubt about his guilt. 4. European Convention on Human Rights jurisprudence. As mentioned above, international developments in human rights law have afforded protection to the principle of the presumption of innocence. The jurisprudence on the European Convention on Human Rights includes a consideration of the legitimacy of reverse onus provisions. Section 6.2 of the European Convention on Human Rights reads, "Everyone charged with a criminal offense shall be presumed innocent until proved guilty according to law." The meaning of Section 6.2 was clarified in the Funders case, Austria v. Italy, 1963, at page 782 and page 784. This text, according to which everyone charged with a criminal offense shall be presumed innocent until proved guilty according to law, requires firstly that court judges in fulfilling their duties should not start with a conviction or assumption that the accused committed the act with which he is charged. In other words, the onus to prove guilt falls upon the prosecution, and any doubt is to the benefit of the accused. Moreover, the judges must permit the latter to produce evidence in rebuttal. In their judgment, they can find him guilty only on the basis of direct or indirect evidence sufficiently strong in the eyes of the law to establish his guilt. Although the Commission has endorsed the general importance of the requirement that the prosecution prove the accused's guilt beyond a reasonable doubt, it has acknowledged the permissibility of certain exceptions to this principle. For example, the Commission upheld a statutory reverse onus provision in which a man living with or habitually in the company of a prostitute is presumed to be knowingly living on the earnings of prostitution unless he proves otherwise. The Commission noted the importance of examining the substance and effect of a statutory reverse onus. It concluded, however, at page 135, the statutory presumption in the present case is restrictively worded. The presumption is neither irrebuttable nor unreasonable. To oblige the prosecution to obtain direct evidence of living on immoral earnings would in most cases make its task impossible. D. Conclusion regarding Section 11D of the Charter and Section 8 of the Narcotic Control Act. This review of the authorities lays the groundwork for formulating some general conclusions regarding reverse onus provisions and the presumption of innocence in Section 11D. We can then proceed to apply these principles to the particulars of Section 8 of the Narcotic Control Act. In general, one must, I think, conclude that a provision which requires an accused to disprove on a balance of probabilities the existence of a presumed fact, which is an important element of the offense in question, violates the presumption of innocence in Section 11D. If an accused bears the burden of disproving on a balance of probabilities an essential element of an offense, it would be possible for a conviction to occur despite the existence of a reasonable doubt. This would arise if the accused deduced sufficient evidence to raise a reasonable doubt as to his or her innocence, but did not convince the jury on a balance of probabilities that the presumed fact was untrue. The fact that the standard is only the civil one does not render a reverse onus clause constitutional. As Sir Rupert Cross commented in the Reed Lectures, the golden thread of the English criminal law, the burden of proof, delivered in 1976 at the University of Toronto at pages 11 to 13, it is sometimes said that exceptions to the Wilmington Rule are acceptable because whenever the burden of proof on any issue in a criminal case is borne by the accused, he only has to satisfy the jury on the balance of probabilities, whereas on issues on which the Crown bears the burden of proof, the jury must be satisfied beyond a reasonable doubt. The fact that the standard is lower when the accused bears the burden of proof than it is when the burden of proof is borne by the prosecution is no answer to my objection to the existence of exceptions to the Wilmington Rule, as it does not alter the fact that a jury or bench of magistrates may have to convict the accused, although they are far from sure of his guilt. As we have seen, the potential for a rational connection between the basic fact and the presumed fact to justify a reverse onus provision has been elaborated in some of the cases discussed above and is now known as the rational connection test. In the context of Section 11D, however, the following question arises. If we apply the rational connection test to the consideration of whether Section 11D has been violated, are we adequately protecting the constitutional principle of the presumption of innocence? As Professors McKay and Cromwell point out in their article, Oakes, A Bold Initiative Impeded by Old Ghosts, 1983, at page 233. The rational connection test approves a provision that forces the trier to infer a fact that may be simply rationally connected to the proved fact. Why does it follow that such a provision does not offend the constitutional right to be proved guilty beyond a reasonable doubt? A basic fact may rationally tend to prove a presumed fact, but not prove its existence beyond a reasonable doubt. An accused person could thereby be convicted despite the presence of a reasonable doubt. This would violate the presumption of innocence. To return to Section 8 of the Narcotic Control Act, I am in no doubt whatsoever that it violates Section 11D of the Charter by requiring the accused to prove on a balance of probabilities that he was not in possession of the narcotic for the purpose of trafficking. Mr. Oakes is compelled by Section 8 to prove he is not guilty of the offense of trafficking. He is thus denied his right to be presumed innocent and subjected to the potential penalty of life imprisonment unless he can rebut the presumption. This is radically and fundamentally inconsistent with the societal values of human dignity and liberty which we espouse, and is directly contrary to the presumption of innocence enshrined in Section 11D. Let us turn now to Section 1 of the Charter. Is Section 8 of the Narcotic Control Act a reasonable and demonstrably justified limit pursuant to Section 1 of the Charter? The Crown submits that even if Section 8 of the Narcotic Control Act violates Section 11D of the Charter, it can still be upheld as a reasonable limit under Section 1, which, as has been mentioned, provides 1. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. The question whether the limit is prescribed by law is not contentious in the present case, since Section 8 of the Narcotic Control Act is a duly enacted legislative provision. It is, however, necessary to determine if the limit on Mr. Oak's right, as guaranteed by Section 11D of the Charter, is reasonable and demonstrably justified in a free and democratic society, for the purpose of Section 1 of the Charter, and thereby saved from inconsistency with the Constitution. It is important to observe at the outset that Section 1 has two functions. First, it constitutionally guarantees the rights and freedoms set out in the provisions which follow, and second, it states explicitly the exclusive justificatory criteria outside of Section 33 of the Constitution Act 1982, against which limitations on those rights and freedoms must be measured. Accordingly, any Section 1 inquiry must be premised on an understanding that the impugned limit violates constitutional rights and freedoms which are part of the supreme law of Canada. As Justice Wilson stated in Singh v. Minister of Employment and Immigration, Supra, at page 218, it is important to remember that the courts are conducting this inquiry in light of a commitment to uphold the rights and freedoms set out in the other sections of the Charter. A second contextual element of interpretation of Section 1 is provided by the words free and democratic society. Inclusion of these words as the final standard of justification for limits on rights and freedoms refers the court to the very purpose for which the Charter was originally entrenched in the Constitution. Canadian society is to be free and democratic. The court must be guided by the values and principles essential to a free and democratic society, which I believe embody, to name but a few, respect for the inherent dignity of the human person, commitment to social justice and equality, accommodation of a wide variety of beliefs, respect for cultural and group identity, and faith in social and political institutions which enhance the participation of individuals and groups in society. The underlying values and principles of a free and democratic society are the genesis of the rights and freedoms guaranteed by the Charter, and the ultimate standard against which a limit on a right or freedom must be shown, despite its effect, to be reasonable and demonstrably justified. The rights and freedoms guaranteed by the Charter are not, however, absolute. It may become necessary to limit rights and freedoms in circumstances where their exercise would be inimical to the realization of collective goals of fundamental importance. For this reason, Section 1 provides criteria of justification for limits on rights and freedoms guaranteed by the Charter. These criteria impose a stringent standard of justification, especially when understood in terms of the two contextual considerations discussed above, namely, the violation of a constitutionally guaranteed right or freedom and the fundamental principles of a free and democratic society. The onus of proving that a limit on a right or freedom guaranteed by the Charter is reasonable and demonstrably justified in a free and democratic society rests upon the party seeking to uphold the limitation. It is clear from the text of Section 1 that limits on the rights and freedoms enumerated in the Charter are exceptions to their general guarantee. The presumption is that the rights and freedoms are guaranteed unless the party invoking Section 1 can bring itself within the exceptional criteria which justify their being limited. This is further substantiated by the use of the word demonstrably, which clearly indicates that the onus of justification is on the party seeking to limit. The standard of proof under Section 1 is the civil standard, namely proof by a preponderance of probability. The alternative criminal standard, proof beyond a reasonable doubt, would in my view be unduly onerous on the party seeking to limit. Concepts such as reasonableness, justifiability, and free and democratic society are simply not amenable to such a standard. Nevertheless, the preponderance of probability test must be applied rigorously. Indeed, the phrase demonstrably justified in Section 1 of the Charter supports this conclusion. Within the broad category of the civil standard, there exists different degrees of probability depending on the nature of the case. As Lord Denning explained in Bader v. Bader, 1950, at page 459, the case may be proved by a preponderance of probability, but there may be degrees of probability within that standard. The degree depends on the subject matter. A civil court, when considering a charge of fraud, will naturally require a higher degree of probability than that which it would require if considering whether negligence were established. It does not adopt so high a degree as a criminal court, even when it is considering a charge of a criminal nature, but still it does require a degree of probability which is commensurate with the occasion. This passage was cited with approval in Haynes v. Wawanesa Mutual Insurance Company, 1963, at page 161. A similar approach was put forward by Justice Cartwright in Smith v. Smith, 1952, at pages 331 to 332. I wish, however, to emphasize that in every civil action, before the tribunal can safely find the affirmative of an issue of fact required to be proved, it must be reasonably satisfied, and that whether or not it will be so satisfied must depend on the totality of the circumstances on which its judgment is formed, including the gravity of the consequences. Having regard to the fact that Section 1 is being invoked for the purpose of justifying a violation of the constitutional rights and freedoms the Charter was designed to protect, a very high degree of probability will be, in the words of Lord Denning, commensurate with the occasion. Where evidence is required in order to prove the constituent elements of a Section 1 inquiry, and this will generally be the case, it should be cogent and persuasive and make clear to the court the consequences of imposing or not imposing the limit. A court will also need to know what alternative measures for implementing the objective were available to the legislators when they made their decisions. I should add, however, that there may be cases where certain elements of the Section 1 analysis are obvious or self-evident. To establish that a limit is reasonable and demonstrably justified in a free and democratic society, two central criteria must be satisfied. First, the objective, which the measures responsible for a limit on a charter right or freedom are designed to serve, must be of sufficient importance to warrant overriding a constitutionally protected right or freedom. The standard must be high in order to ensure that objectives which are trivial or discordant with the principles integral to a free and democratic society do not gain Section 1 protection. It is necessary, at a minimum, that an objective relate to concerns which are pressing and substantial in a free and democratic society before it can be characterized as sufficiently important. Second, once a sufficiently significant objective is recognized, then the party invoking Section 1 must show that the means chosen are reasonable and demonstrably justified. This involves a form of proportionality test. Although the nature of the proportionality test will vary depending on the circumstances, in each case, courts will be required to balance the interests of society with those of individuals and groups. There are, in my view, three important components of a proportionality test. First, the measures adopted must be carefully designed to achieve the objective in question. They must not be arbitrary, unfair, or based on irrational considerations. In short, they must be rationally connected to the objective. Second, the means, even if rationally connected to the objective in the first sense, should impair as little as possible the right or freedom in question. Third, there must be a proportionality between the effects of the measures which are responsible for limiting the charter right or freedom and the objective which has been identified as of sufficient importance. With respect to the third component, it is clear that the general effect of any measure impugned under Section 1 will be the infringement of a right or freedom guaranteed by the Charter. This is the reason why resort to Section 1 is necessary. The inquiry into effects must, however, go further. A wide range of rights and freedoms are guaranteed by the Charter, and an almost infinite number of factual situations may arise in respect of these. Some limits on rights and freedoms protected by the Charter will be more serious than others in terms of the nature of the right or freedom violated, the extent of the violation, and the degree to which the measures which impose the limit trench upon the integral principles of a free and democratic society. Even if an objective is of sufficient importance and the first two elements of the proportionality test are satisfied, it is still possible that because of the severity of the deleterious effects of a measure on individuals or groups, the measure will not be justified by the purposes it is intended to serve. The more severe the deleterious effects of a measure, the more important the objective must be if the measure is to be reasonable and demonstrably justified in a free and democratic society. Having outlined the general principles of a Section 1 inquiry, we must apply them to Section 8 of the Narcotic Control Act. Is the reverse onus provision in Section 8 a reasonable limit on the right to be presumed innocent until proven guilty beyond a reasonable doubt, as can be demonstrably justified in a free and democratic society? The starting point for formulating a response to this question is, as stated above, the nature of Parliament's interest or objective which accounts for the passage of Section 8 of the Narcotic Control Act. According to the Crown, Section 8 of the Narcotic Control Act is aimed at curbing drug trafficking by facilitating the conviction of drug traffickers. In my opinion, Parliament's concern that drug trafficking can be decreased can be characterized as substantial and pressing. The problem of drug trafficking has been increasing since the 1950s, at which time there was already considerable concern. Throughout this period, numerous measures were adopted by free and democratic societies at both the international and national levels. At the international level, on June 23, 1953, the Protocol for Limiting and Regulating the Cultivation of the Poppy Plant, International and Wholesale Trade in and Use of Opium, to which Canada is a signatory, was adopted by the United Nations Opium Conference held in New York. The Single Convention on Narcotic Drugs, 1961, was acceded to in New York on March 30, 1961. This treaty was signed by Canada on March 30, 1961. It entered into force on December 13, 1964. As stated in the preamble, addiction to narcotic drugs constitutes a serious evil for the individual and is fraught with social and economic danger to mankind. At the national level, statutory provisions have been enacted by numerous countries, which, inter alia, attempt to deter drug trafficking by imposing criminal sanctions. The objective of protecting our society from the grave ills associated with drug trafficking is, in my view, one of sufficient importance to warrant overriding a constitutionally protected right or freedom in certain cases. Moreover, the degree of seriousness of drug trafficking makes its acknowledgement as a sufficiently important objective for the purposes of Section 1 to a large extent self-evident. The first criterion of a Section 1 inquiry, therefore, has been satisfied by the Crown. The next stage of inquiry is a consideration of the means chosen by Parliament to achieve its objective. The means must be reasonable and demonstrably justified in a free and democratic society. As outlined above, this proportionality test should begin with a consideration of the rationality of the provision. Is the reverse onus clause in Section 8 rationally related to the objective of curbing drug trafficking? At a minimum, this requires that Section 8 be internally rational. There must be a rational connection between the basic fact of possession and the presumed fact of possession for the purpose of trafficking. Otherwise, the reverse onus clause could give rise to unjustified and erroneous convictions for drug trafficking of persons guilty only of possession of narcotics. In my view, Section 8 does not survive this rational connection test. As Justice of Appeal Martin of the Ontario Court of Appeal concluded, possession of a small or negligible quantity of narcotics does not support the inference of trafficking. In other words, it would be irrational to infer that a person had an intent to traffic on the basis of his or her possession of a very small quantity of narcotics. The presumption required under Section 8 of the Narcotic Control Act is over-inclusive and could lead to results in certain cases which would defy both rationality and fairness. In light of the seriousness of the offense in question, which carries with it the possibility of imprisonment for life, I am further convinced that the first component of the proportionality test has not been satisfied by the Crown. Having concluded that Section 8 does not satisfy this first component of proportionality, it is unnecessary to consider the other two components. Conclusion: the Ontario Court of Appeal was correct in holding that Section 8 of the Narcotic Control Act violates the Canadian Charter of Rights and Freedoms and is therefore of no force or effect. Section 8 imposes a limit on the right guaranteed by Section 11D of the Charter, which is not reasonable and is not demonstrably justified in a free and democratic society for the purpose of Section 1. Accordingly, the constitutional question is answered as follows. Question: is Section 8 of the Narcotic Control Act inconsistent with Section 11D of the Canadian Charter of Rights and Freedoms, and thus of no force and effect? Answer: yes. I would therefore dismiss the appeal. The reasons of Justices Esty and McIntyre were delivered by Justice Esty. I would dismiss this appeal. I agree with the conclusions of the Chief Justice with reference to the relationship between Section 11D and Section 1 of the Canadian Charter of Rights and Freedoms. For the disposition of all other issues arising in this appeal, I would adopt the reasons given by Justice of Appeal Martin in the court below. Appeal dismissed.